Good afternoon, and welcome to today's webcast on recent and upcoming Supreme Court IP-related cases. I'm Joel Whitney from the Syracuse University College of Law. Today's webcast is sponsored by the New York State Science and Technology Law Center, which is funded by NYSTAR. I'm pleased to introduce Professor Shubha Ghosh, the Crandall Melvin Professor of Law at Syracuse University College of Law, and the Director of the Technology Commercialization Law Program. Shubha?
Thank you, Joel, and welcome back. We've had a little hiatus over the summer in the webinars. I think our last one was in the end of May on finance issues, but I'm excited to be back and launching another year of webinar series. We've got some good things planned, including a talk about CRISPR on September 14th, and then some patent ethics and sharing economy webinars in October. And then in the real world, in November 17th, NYSTAR, New York State Science Technology Law Center, and the program is working on the next conference that's going to be held in Syracuse. So look out for details about that. I'm Shubha Ghosh. I'm going to be launching the particular series this year with a discussion about the IP cases that were decided by the U.S. Supreme Court last term. I think it's worth spending some time talking about these cases because there are a lot of them and they covered lots of interesting and practical areas. So for the next hour or so, I'm going to be going through the 8 cases, believe it or not, that came down during the last term, and then talk about 2 cases that are probably going to be 2 of many again that are before the U.S. Supreme Court in the 2017-2018 term. And both of those are also very interesting cases and raise probably even more important issues than the ones that were decided this past term. So once again, feel free to send in your questions. I'll keep an eye out and respond as appropriate. But feel free to send your questions at any time. We've got 2 in the queue, and they're really good, and I'm looking forward to getting more as we progress. So just to give you an overview of what happened last term, there are 8 cases that were decided, and these are in areas of copyright, patent, and trademark. Most of them were in the patent area, though there were 2 cases that were in the area of design that involved both patent and copyright issues. And there's also an important trademark case that involved the First Amendment that has some implications for patent and copyright potentially. And just to give you a sense of 8 cases, how that fits into the entire docket from last term, the Supreme Court, obviously hears lots of orders. I didn't count the number of orders it issued. But in terms of final published opinions and oral arguments, there were 70. So we're talking about more than 10% of the final published opinions that resulted, that were IP related. So that's quite a bit. And as I mentioned, there are 2 big patent cases in the upcoming term. And those are really dealing with fairly seminal issues. And there may be other things that the court will accept cert on. Very likely there will be. I'd be surprised if we get up to 8 again, but you never know. We see in this past term, as well as in the 2 cases that are pending, sort of a mix of very important issues, but also some cleanup of some technical issues that were left over or had been lurking in the background in the lower courts. And so one of the commentaries about why the court took so many IP cases, it just may be a matter of circumstance, just the issues that were percolating in the lower courts just welled up during this particular time. There are other theories that said that for most of last term, really up until March or early August, the court only had 8 members. And so they tried to take on cases that may have been more technical in nature, that I mean by that legally technical, and really try to avoid some of the more political or controversial type cases. And I guess many of the cases that you see sort of fit that mold, from cheerleader costumes to technical questions about process patents. The court saw in these IP cases issues that may have been relevant to business and issues that may not be things that would be too controversial or headline grabbing. and therefore they may be more easy to grant consensus on. And if you look at the final outcome in these cases, there was consensus. There were maybe one or two dissenters scattered in the mix, but generally these tended to be 8-0 opinions. And for the ones where there were dissenters, or at least concurring opinions, there was some core consensus that we could identify. That's certainly true in the case that I'll talk about in a few minutes involving trademarks and the First Amendment, the Mittal versus Dam case, which is one of the few cases in this mix that actually did get a lot of headline attention, and we'll spend some time talking about that. So what I'm going to do is present the 8 cases in the order in which the Supreme Court released them. The first opinion was released sometime in December of last year, December 2016, and the last opinion came out roughly the last week of the term, basically the last week of June. So we should have a fairly lively discussion. Keep the questions coming, and let me proceed through that. And then I'll conclude by talking about the 2 big pending cases, as well as trying to glean some lessons from what we had this past term. So the first big case was Samsung versus Apple. This was a closely watched case. It's one that did attract some of the headlines because of the parties involved, as well as the products involved. This was a design patent case. And so Apple had a design patent on the look and feel of its iPhone, and Apple's claim was that Samsung had basically misappropriated and infringed upon that look and feel that was captured in the design patent. So if you look at the picture on the left-hand side, these are images from Apple's design patent. This case is a really interesting one because this is one of the first design patent cases that the Supreme Court has held and went into in some depth in probably over nearly a century. So I'll talk a little bit about some of the previous cases and how that affected this one. But the issue in this case had to do with damages. The basic issue was Samsung was found to have infringed Apple's design patent, and in terms of the damages that Apple would be owed, they were based upon the entire value of the iPhone, as opposed to somehow taking apart that value and attributing it to the particular design that was protected. And this picture shows you the actual elements that were protected, which is really a small part of all of the elements that are included in an iPhone. So we're ending up with a judgment in the billions of dollars, and the issue is whether the lower court should have taken apart or disaggregated the amount of royalties that Apple would be owed based upon the underlying technology. So the statute at issue is this provision of the design patent statute. And the design patent statute are only 3 provisions that are in the 35 U.S.C. in the Patent Act. And so it's a very, in terms of statutory background, a very thin area of the law. It is also in terms of court decisions. There aren't that many court decisions either. And so the Supreme Court had to get into the interpretation of this particular provision to sort out exactly how much the damages should be. I'll read the language. Whoever during the term of a patent for design without license of the owner applies the patent design or any colorable imitation thereof to any article of manufacture for the purpose of sale, or sells or exposes for sale any article of manufacture to which such design or colorable imitation has been applied, shall be liable to the owner to the extent of his total profit, but not less than $250. And the question that arose here is, what do we mean by article of manufacture? Is that the entire product, or does that just mean a particular component of the product that may have been actually covered by the design patent? And the lower court and the federal circuit, in light of a previous Supreme Court precedent, basically said it's the entire product, the entire iPhone, which means that Samsung would be liable to Apple for the entire profits associated with the iPhone um, times the number of iPhones that would be sold. That's how we get up to $1 billion fairly quickly. So the technical language is, what do we mean by article of manufacture, and how do we think about the total profit that's been the basis for calculating damages? The background to this case is a 1880, let me go to the date, 1886 decision, Dobson versus Dornan, which is a classic case of design patent remedies that looked at language very similar to the one that I just read. The technology, if you will, or the product at issue in that case, however, was a rug. In fact, there was a lot of litigation involved design of rugs. The 1880s, you sort of had the start of the Gilded Age. People had a lot of money. People were spending it on frills like rugs, and you had a fairly active market where companies were imitating rugs that were successful in the marketplace, and so you had lots of litigation like this one. And here, the design patent would again cover only the pattern on the rug, but the question is, the remedies would be depending upon the total profits, which the court said in Dobson versus Dornan would be the entire rug being the article of manufacture. And so the lower court in the Apple versus Samsung dispute took that logic to say that if in Dobson versus Dornan the article of manufacture is the entire product, then the relevant product in the Apple case is the entire iPhone, and that should be what the basis is for figuring out exactly what the damages would be, rather than any sort of apportionment that would be necessary to figure out the damages. In the case of rugs, and we'll get to this issue in a minute in the context of iPhones, we can see why the court might have said what it did way back in 1886, over 130 years ago. It's very hard to take apart the value of the rug and the value of the design of the rug. Certainly we can look at the materials, but the materials of the rug probably are a small, important component and part of the total value of the rug. But often people buy the rug purely for the design. That's in some ways what the heart of the product is from a consumer perspective. And so in some ways it's not illogical for the court to have said that the value of the rug is really a good measure, maybe full measure of the value of the protected design in this particular product. But the Supreme Court resolved this issue, looked at this fairly closely, both in terms of the logic of Dobson as well as the statutory language. Article of manufacture is not the entire product, and therefore the jury verdict here of $400 million was thrown out. Apple then has to show some sort of apportionment. If there is some sort of a multi-component product, the article of manufacture may be the individual component, and here the individual component would be the surface or the screen of the iPhone. The screen of the iPhone is only one of the components that make the iPhone what it is, and therefore the court would have to value that in some way in order to figure out what the damage would be. Now, I don't think people were too surprised by the decision. It's kind of an interesting issue that we'll see a couple of times coming up in these cases about precedent versus policy or precedent versus logic. Some people may have felt that the court would have just simply upheld precedent in Dobson versus Dornan and say article of manufacture is the entire product. But Dobson, was a fairly narrow precedent in a very different time involving a different product. So it's not surprising that the court took a slightly different tack than it did in Dobson versus Dornan. Notice the court is very clear to talk about multi-component products. A rug is not a multi-component product. In some trivial sense it is, but the Dobson versus Dornan case probably rested upon the reasoning that the real value of the rug was in its design. The value of an iPhone, comes in part from the design, especially the protected design in this case. But there's obviously a lot of patented subject matter. There are lots of copyrights. There's lots of software. There are lots of things that make the iPhone valuable, and therefore the particular component that was infringed has to be apportioned or sorted out. The real kind of frustration in this case, of course, is the Supreme Court doesn't tell us how to identify the component and value it. One way to maybe identify the component and value it is to say, well, the issue here is the screen in total. So the article of manufacture, if you go back to the design patent here, is the screen. And in some ways, it might be possible to value the screen readily. You can think about a replacement cost for a screen. Some of the listeners may have had to do that in the past. We can talk about the cost of creating the screen. Maybe that's another aspect of the valuation. So it'll be interesting to see how the lower courts, treat this open question of valuation. Again, it may be wrong to say that it's the screen that's the relevant component, because as a technical matter, it's the design of the screen. It's the interface between the screen and the user. It's the particular arrangement of parts on the screen that make it valuable and is the element of the protected design. And so, the lower courts might break it down even further in terms of identifying what the component is. The point is, the Supreme Court in this decision did not give us much guidance on it. There are issues of valuation that have been discussed that come up, for example, in determining royalties. This issue comes up again, for example, in determining FRAND royalties, fair, reasonable, and non-discriminatory terms. And so it's not as if the courts have had no experience in valuation. It's just that this is a different context and there are open questions. And we'll definitely keep an eye on this case to see how the lower courts address it. I would be so surprised if the issue of valuation goes back up to the Supreme Court, because that's not technically a legal question. That's more of a factual question. The statute does not really lay out any methodology for valuation. And so there wouldn't be a statutory question. There's not necessarily really a constitutional or other federal question that could percolate up. So this may be one of these things where we have the lower courts sort out different types of valuation methods, and it largely becomes issues of evidence and of fact in terms of how what methodology, if any, the courts settle on in this particular area. So the next case, is LifeTech versus Promega. And this is an interesting case in the life sciences involving genetic testing toolkit. The toolkit is basically sold to law enforcement agencies, both in the U.S. and outside the U.S., that use it, for example, in criminal investigations and in law enforcement. So Promega had the patent on the toolkit, and it sublicensed the patented toolkit for genetic testing to LifeTech for manufacture. And LifeTech's license with Promega basically did have a field of use restriction that's worth mentioning here. And so LifeTech would manufacture it for the purposes of clinical and research markets. And so it would not be directly involved in law enforcement. It would be working more, for example, with research labs or universities in terms of how the toolkits were manufactured by LifeTech. The kit consisted of 5 enzymes. LifeTech would make some of these enzymes in the U.S. and export one of the enzymes to the UK. LifeTech would make one of the enzymes in the U.S. and export it to the UK, where it was combined with the other enzymes to complete the kit. And then it was either imported back in the U.S. or sold in other markets. And so Promega claimed that LifeTech was liable under provision 271F1, which imposes liability for exporting all or substantial portions of a component overseas for manufacturing a patented invention. So it's worth spending some time here to provide some background. 271F1 of the Patent Act was enacted in the mid 1970s in response to another Supreme Court decision called Deep South Packing, and that's a very interesting case involving shrimp deveiners. So the company had a patent on a machine that would make it easier to devein shrimp. Basically, you would feed the shrimp. Part of the machine would cut the back of the shrimp so that it would break into the shell, and the remainder of the machine would basically suck up and strip the shrimp of the shell, so you get a fairly clean shrimp that could be ready for distribution after some more processing. So it basically mechanized the deveiner, and in the Deep South Packing case, which was obviously before 271 F1, the infringer would basically send the components overseas, where they'd be put together to make the patented item, and then the patented item would be further sold overseas. And so basically what the infringer was doing was getting around the U.S. patent. The particular invention at issue was not covered by the country in which the manufacturing occurred, and the patents, the technology would be sold in countries where there wouldn't be any patents involved. So the issue here was in Deep South Packing that the patent owner raised was that should be treated as some form of patent infringement, either facilitating patent infringement or maybe even direct infringement by sending the components, even though they were made overseas and sold overseas, to make that patent infringement. So there's a little bit of extraterritoriality here in terms of how the patent laws would apply to overseas behavior. But the Supreme Court basically in Deep South Packing said that was not patent infringement under the statute as it was written in the time. So Deep South Packing comes up in 1972. No infringement for sending the components of a patented item overseas where they're put together. And Congress responded with 271 F1, which basically imposes liability for exporting all or substantial portions, even if it's made overseas and sold overseas. So this act of exporting components, all or substantial portions, would be infringing. So the issue that arose in Lifetech versus Promega is twofold. One is, how does this statute apply to a biotech technology, which is basically a toolkit, a genetic toolkit, really a process-based patent? And how does it apply to when a situation where only one of the 5 enzymes, is that all or substantial portions of the component? So there's some interesting echoes here of Apple versus Samsung. This is a very important theme that's come up in lots of Supreme Court cases, not just simply the ones this term, as to how to deal with multi-component products. It came up in the eBay case in terms of injunctive relief. It comes up in cases involving divided infringement for patents. It comes up here again in the context of how exactly do you define components for the purposes of 271 F1. So the district court found no liability because a single component was not all or substantial. The Federal Circuit took a more qualitative approach, basically saying that, well, it's not just simply counting up the components. It really is about the heart of the invention and how the invention would operate. So even if this was only 1 out of 5 or 20%, we dealt with something that was very important for the invention to operate, and therefore this would be substantial under 271 F1. The Supreme Court reversed the Federal Circuit, finding 7-0. I think Justice Roberts, if I'm not, had to recuse himself from this case. One of the justices, though, had to recuse themselves. I'm pretty sure it was Roberts. And basically the Supreme Court found for the infringer, Lifetech, or the alleged infringer, Lifetech, reversing the Federal Circuit. And the court largely did it on the grounds of the statutory reading. Substantial means substantial. It has to be more than one. or really, it has to be something that, when you're thinking about the heart of the invention, the Congress was conceiving of something closer to the Deep South packing situation, where largely all of the components or most of the components were being sent overseas and being reassembled. So again, there is some openness here, as with any of these decisions. Um, if you're dealing with a particular case, much like the one in Promega, where you have multiple enzymes or multiple chemical components, just simply sending one over probably does not meet the threshold for 271F liability, but it's not quite clear how far that would go, how far you can get away with this in terms of exporting components for remanufacture. So there is one question about this. What are the potential implications of the ruling on the technology from the original patent from which it was sublicensed? And so that's an interesting question. There are a couple of issues to think about in terms of potential implications. One, again, is this open-endedness about what exactly do we mean by a component. The patent language for the Promega patent did talk about enzymes, and so that might be the right unit of analysis based upon the disclosure in terms of figuring out exactly how many components were in this patented invention. So there's that point that might have some guidance for future cases. Does the disclosure tell you something about what constitutes a component? There might be another issue here that's fairly important about how Deep South packing would extend to non-mechanical, non-manufactured items such as biotech patents, how it might apply to software, and how we think about liability for these particular exports. There was a decision in the Microsoft case about a decade ago which raised similar questions about exporting components for the purposes of 271F liability in the software case. And the court also took a very narrow view of liability in that case. So when we're dealing with these new technologies, biotechnology, they're not really new now, but new when compared to what was at issue in Deep South packing, process-based, things that have less clear boundaries than a machine might have. The court is now saying that 271F might apply, but it seems to have a little bit more stringent standard for when liability will actually be imposed. So the next case is also another important, closely watched case by practitioners, SCA Hygiene versus First Quality. This is part of, leftover cases in what I call the diaper wars. In the 1990s and even in the aughties, there was just a series of patent litigation involving diapers. There's a lot of technology, a lot of patented issues in that particular field. And SCA Hygiene held a patent on the technology embodied in diapers. And the background facts of this are important in terms of any kind of pretrial negotiation, because the issue here had to do with latches. In other words, did the patent holder sit on their rights too long before bringing the infringement lawsuit, and therefore they were barred from bringing the claim? So latches is an equitable tolling doctrine that basically says certain claims die if the patent holder has not acted on them quick enough. And so that's why these background facts are important. In 2003, SCA notified First Quality that it was infringing SCA's patent. First Quality responded that SCA's patent was invalid in light of First Quality's prior art patent. So there's a fundamental dispute about the validity of the patent. In 2004, SCA initiated a re-examination of its patent, and in 2007, the USPTO upheld SCA's patent. And so in 2010, SCA initiated a lawsuit against First Quality. The claim was dismissed because of latches and estoppel. Notice the dates are important between 2004 and 2010. There was ongoing patent infringement or alleged patent infringement during that period. And so SCA did file its lawsuit within the 6-year statutory statute of limitations for patent claims. So it was within that 6-year statutory statute of limitations. But nonetheless, the claim was dismissed because of SCA sitting on its rights, arguably for almost 7 years, maybe even more, depending on how you count the dates. And even within the period of the statute of limitations, the view is they could have brought it earlier before the statute had completely told, and therefore SCA was sort of sitting on its rights. The laches doctrine is kind of an equitable doctrine, a sense of that if you don't enforce your rights, in some sense you lose the ability to enforce them in order to be deal with any reliance issues, in order for the patent owner not just simply to allow damages to accrue and then enforce their rights. So this case is doubly interesting because during the appeal, from that dismissal, the Supreme Court ruled that laches was not a defense in copyright suits for damages during the statute of limitations period, and this was decided in an interesting case from 2014 called Petrella versus MGM. It's an interesting case for those who are a fan of the movie Raging Bull. Petrella is I forget exactly, maybe daughter of Jake LaMotta. The movie was based upon Jake LaMotta's life and memoirs. And so Petrella had been negotiating with MGM over the movie, the digital and video rights when Raging Bull was released. Raging Bull itself having come out, I think, in 1980 or so. It's a fairly old movie. But the video coming out, obviously quite a bit later. And so the court there said that Petrella did bring the case, bring the claim within the 3-year statute of limitations. The lower court said that Petrella had been sitting on her rights for a much longer period and therefore dismissed based on laches. And the Supreme Court said no, as long as the copyright owner brings the cause of action within the statutory term, then laches does not apply. And of course, the natural question then is, does the reasoning of Petrella apply to the patent context? SCA Hygiene basically saying that it did, and therefore seeking a reversal of the lower court ruling. So the question is laches an available defense to a patent infringement claim for damages during the 6-year statute of limitations period? Supreme Court rules 7-1 that laches is not a defense. It basically followed its reasoning in the Petrella case, looking very closely at the statute and the background to see whether Congress intended laches to survive, as a defense, and the court ruled that the statutory statute of limitations would hold, and laches does not apply. So a lot of statutory language, the statutory analysis. There weren't that many cases the court found to show that laches had been applied as a general matter in the common law, and therefore you've got a situation where the court basically extended its reasoning from Petrella to the patent context. Now, the one point that's interesting here is that there was one dissenter, and that's Justice Breyer. Justice Breyer was also a dissenter in Petrella, basically saying laches should apply, that the IP owner, whether patent or copyright owner, really has to act quickly, and if they're sitting on their rights, the court basically should take that into consideration in determining whether to dismiss the lawsuit on equitable grounds. So Justice Breyer was, in this sense, consistent. He was on the same side of this laches issue in both Petrella and in SCA Hygiene. But Petrella also had two other dissenters. Those are Justice Roberts and Justice Kennedy. And they, at least on this laches issues, switched their vote when it came up in the context of patents. Whatever that might mean, we can read whatever we want into it. It may be an issue where once Petrella was decided as precedent, Justice Roberts and Kennedy had to follow that precedent or felt compelled to. Maybe they just simply changed their mind and realized they may have been wrong in Petrella. It's really hard to say, but it's just kind of interesting to see that type of switch. Breyer, however, is really concerned about abusive IP litigation, whether it's in copyright or in patent. And in other cases, he's been very wary about abusive litigation in patents and certainly also in copyright. And therefore, he wanted to give the lower courts the full arsenal to try to dismiss cases in situations where equity might allow it. So again, important case, again, sort of a technical case, and in some ways not that surprising in light of what the Petrella decision held. So here's a case that got, again, some press. It certainly was talked about a lot by practitioners because the Supreme Court had addressed an issue that it really hadn't looked at in 50 years. The last decision was Mazur versus Stein, I think in 1953. And this issue, though, comes up quite a bit in practice, and that is copyright protection for design. The issue here is the design of the cheerleader costume. These are the registrations that were held by the copyright owner, Star Athletica, in this particular case, for these particular items. These are design copyright cases. So there's an interesting parallel here with the design issues that we saw in Apple. Two design cases in one term is kind of interesting. I think there's some commentators, not IP commentators, but Supreme Court commentators, that pointed to this case as saying, well, the court really is trying to avoid controversy by taking this kind of a trivial case when they're short-staffed, when there are only 8 justices. And I don't know if that's fair totally. I mean, from an IP perspective and certainly from a copyright perspective, this is kind of a big deal case as far as the scope of design copyright. And the whole issue of copyright and IP protection for fashion is a big question. It's a big industry. And so in that sense, it's not really a trivial case. The particular issue in this case had to do with this statutory language. Things like design of clothing, design of three-dimensional object. These are treated as pictorial, graphic, and sculptural work for the purposes of copyright. And the definition of a pictorial, graphic, and sculptural work is it's a work that includes works of artistic craftsmanship insofar as their form, but not their mechanical or utilitarian aspects are concerned. The design of a useful article, as defined in this section, shall be considered a pictorial, graphic, or sculptural work only if and only to the extent that such design incorporates pictorial, graphic, or sculptural features that can be identified separately from and are capable of existing independently of the utilitarian aspects of the article. So that's a mouthful. But what the statute is saying, is reflecting, is the concern that Congress had that when you protect design, you're not protecting the product itself. So to go back to the case of Mazur versus Stein, that had to do with a lamp, the protection for the design of a lamp. And the court wanted to make sure in that case that the design of the lamp didn't necessarily give protection to the lamp. The lamp is not covered by copyright law. Anyone could make that lamp unless it was also protected by patents or trade secrets. But if it's just a pure design, then nobody can copy that, right? So if you think about this example with the cheerleader outfit, anybody can make a cheerleader outfit. The question is whether they can use the design of this cheerleader outfit. And so the question is, can you identify the design elements, the aesthetic or artistic design elements that are separate from the clothing itself? And if you cannot separate them, then there is no copyright protection for the design. If you can separate them, then there is protection for the design elements, but obviously there would be no protection for the underlying useful article, the clothing. So a lot of the debates about design copyright, if you go back to the 1950s and they're in the context of Mazur versus Stein, one example you can think about is automobiles. So the chassis of an automobile has both useful elements as well as the body of an automobile, has both useful elements and artistic elements. And sometimes it may not be possible to separate those two. To the extent you cannot separate them, then there's no copyright protection. To the extent that you can separate them, then the design elements do get protected. So what types of elements of an automobile body might be separated? Well, think about the hood ornament. That's probably an easy example to see. The hood ornament of an automobile, let's say it's the Jaguar on the Jaguar or the peace sign on a Mercedes-Benz, that can be separated from the body. It can have independent existence from the body, and therefore that can get design protection separately. And the rest of the body, to the extent you cannot separate them, you can't. So there are lots of interesting issues here. Again, there's this issue that we've talked about a number of times regarding components. And what do you do with items that have multiple components here? Here, the components at issue for copyright protection are the aesthetic, artistic, design elements, and the purely functional, utilitarian, practical elements of a particular item. And so you might wonder, if you lose design copyright, what's left? Well, this is where design patent comes into play. Because remember, design patent has to be for a particular article of manufacture. So the way in which the law is divided up is that if you can separate them, then the separate design features that are separate from the article of manufacture would get design copyright protection. But if you cannot separate them, you don't get design copyright, but you can get design patents. So that's kind of a little bit of a background. There may be questions about that, obviously. But let me kind of give you a little bit more about how this came to the court. Basically, you have the statutory provision that, in light of Mazur versus Stein, got enacted as part of the 1976 Copyright Act. And so since Mazur versus Stein in 1953, but especially since this 1976 version of the Act, you've had lots of cases regarding design copyrights, and the courts have been all over the place regarding how do you do this separation of design and usefulness. At my last count, there are probably about 12 different tests, and they're all very different in terms of their emphases. So some courts look to see what the purpose of the artist was. Did the creator mean to integrate the design with the product or to have them separately? If the creator intended integrated design, then no copyright protection. Other courts would look at what consumer perception would be. So if consumers would look at it and see a separate design from the product, or if they only bought the product for the design, think about the rug example, then the design could be separated and there would be copyright protection. The bottom line is the courts were all over the place. And I mentioned that there were about maybe 12, maybe 13 tests, depending upon how you count them. The thing that's very interesting about there being so many tests is that a lot of the litigation tended to be focused on only about 3 or 4 circuits. The Second Circuit, our own circuit, the Seventh Circuit, and the Ninth Circuit, where a lot of these design issues and copyright got litigated. So it's interesting to sort of imagine you have 3 circuits that come up with 13 tests. So I thought it was about time that the Supreme Court granted cert on this issue. People can disagree about what the test is, but this is what the Supreme Court said the test should be. And so a design feature is eligible for copyright protection if, and so there are 2 parts to this, a feature can be viewed as a 2D or a 3D work of art, separate from the useful article, and the feature, when separated from, could be imagined as a pictorial, graphic, or sculptural work when viewed independently or in a different medium. So let's see how they apply that to the cheerleader outfit. What they basically said here is, if you look at the chevrons and the stripes and the coloring, well, this just happened to be on a cheerleader uniform. It could just as easily have been on a canvas. And so on that canvas, it would be viewed as some sort of a painting. It may not have been a great painting, but that's not what we're talking about here. It's something that would be viewed as a copyrightable work if it was done on a canvas, or if it was done on a mural, or if it was done on some other medium, if it was done on, for example, wallpaper on a web page. So in all of those other situations, that type of a coloring and pattern of the dress on the dress can exist separately, and therefore those elements would be protected under copyright because there is that separate existence. So what might not be protected? And the court talks a little bit about this. If you think about the cut of the cheerleader outfit, the cut of the cheerleader outfit may be very difficult to separate from the cheerleader outfit itself. I guess you could imagine tracing the cut of the cheerleader outfit and putting on the canvas, but that would just be another representation of the cheerleader outfit, and therefore would not have any kind of separate existence as a work from the outfit. Now, this gets very heady and metaphysical. What it kind of means in practice is, if you're seeking design protection under copyright law, really pick and choose those elements that could be placed on any medium, not just simply the medium of your particular useful article, whether it's clothing, whether it's a lamp, whether it's a car body, whether it's a dress dummy. You have to have those elements that could have some sort of separate existence and be able to identify them. So the good news is that the court has taken 13 tests and basically said, no, we're only going to have this one test. And once again, the devil is in the details as far as what future courts do with this. There was some division in the court as far as what the test should be. There were some dissenters. Justice Ginsburg had a dissent to basically say that there should be copyright protection, but on different grounds than the separation. Justice Breyer had a very stringing dissent, basically saying that this test is unworkable. How do you do this separation? And he had some very colorful and imaginative example involving a shovel. Wouldn't a shovel get copyright protection because you could do a drawing of a shovel that looks like a shovel but is different from the shovel? And you can take a look at the dissent. It's kind of fun, if you like, for lack of a better term, to read and try to figure out exactly what he meant by the shovel example. The point is, if you just took a drawing of a shovel, the drawing is different from the shovel itself, and so it would not have a separate existence in terms of the shape of the shovel. It would be a bit like the cut of the dress, in my opinion, that would not exist separately from the dress. So therefore, no copyright protection for that. Maybe design patent protection if it meets those requirements, but no separation there. I think there's one question regarding this case. Were there any prior cases that provided significant basis before? And as I mentioned, this issue of design copyright has been litigated, and there were at least 13 different tests. So at least there are 13 different cases that we could go back and look to. They're all on the lower court level. The Mazur versus Stein case did not address the separability issue. It just simply said that design protection under copyright law is possible. It's consistent with copyright law. But then you had Congress responding. You had all of the circuits coming up with different tests. And then you have Star Athletica, where the court says, okay, there have been all of this test. This is the final word about what the test will be for separation. So look out for this case, an interesting one to see how it comes out. Now, TC Heartland versus Kraft Food is the next in the series. That got a lot of attention because of the patent venue issue. You've got two statutes regarding venue. The patent venue statute is 28 U.S.C. section 1400B. Basically says that the civil action for patent infringement may be brought in any judicial district where the defendant resides or where the defendant has committed an act of infringement and has a regular and established place of business. Under the current general venue statute, Section 1391, however, a corporate defendant for venue purposes resides in any jurisdiction where it is subject to personal jurisdiction by the court, except as otherwise provided by the law. And so the question is venue proper over a patent defendant under the narrow standard or the broader one? And that makes a difference because the broader standard was being used by patent owners to basically find jurisdictions where there may have been some minimal contacts in order to bring the defendant in, but it may have been a jurisdiction or venue that was brought that was more favorable to patent owners. And so you got the situation where certain jurisdictions, Eastern District of Texas is the one that gets often singled out, but also Northern District of California, Northern District of Virginia, Delaware, increasingly so, as ones that are more patent friendly, and patent owners use this broader venue statute to try to bring cases in that jurisdiction, even though there was a more narrow patent venue statute that seemed to be covering where these cases should be brought. So the Kraft Food brought its patent suit against TC Heartland in Delaware. TC Heartland is an Indiana corporation headquartered in Indiana. TC Heartland moved to change venue to Indiana as Delaware was not a proper venue under the patent venue statute. The background to this case is again a 1957 decision, Forco Glass versus Transmira. The Supreme Court held that the general venue provision did not alter the specific patent venue provision. Patent venue is proper in the state of incorporation, not any venue where there is personal jurisdiction. So the narrower venue statute would apply under Forco Glass. The narrow venue here would be one where the defendant resides or where the defendant has committed an act of infringement and has a regular and established place of business. Delaware would not be that under that standard in the Kraft Food litigation. So, this issue has come up. You might think that it had been decided in 1957, but there had been a lot of amendments to these venue statutes over time. I won't go into all of the amendments because of time. And so this issue then crept up again. And what the Supreme Court did is just affirmed its 1957 ruling in Forco Glass, looking at the current language of both the patent venue and the general venue statutes. The specific patent venue statute applies. Even though Congress did amend the general venue statute, the court found no indication that Congress meant to overrule Forco Glass or alter the meaning of the specific patent venue statute, and therefore the Federal Circuit erred in ruling in favor of the patent owner and ruling in favor of the general venue statute. So this case got a lot of press because of this issue of patent reform, the issue of non-practicing entities. It certainly does have some effect on patent litigation. Whether this will limit frivolous patent litigation is just an open question. Maybe we'll see. Certainly, practitioners in jurisdictions like Texas are focusing on things because Eastern District of Texas may no longer be a venue of choice or that's available under the more specific patent venue statute, and that would apply to other rocket dockets or preferred venues such as Delaware. So we'll see how it plays out. In the background to this case, there are a lot of people who thought the decision would put a nail in some of the abuses of the patent system. I'm a bit more skeptical about that. So let me go through some of the other cases. We may go a little bit over 2 o'clock. Impression Products versus Lexmark. This had to do with the idea of patent exhaustion. Lexmark sold its printer cartridge under various restrictions on reuse. Impression Products is one of many companies that bought used cartridges and refilled and resold them throughout the world. Impression Products would obtain the used cartridges overseas and resell them in the US. And the issues were, can a patent owner impose contractual restrictions on the sale of product containing patented technology such that violation of the restrictions give rise to a claim for patent infringement? And the second issue is, can patent rights be exhausted only by a sale within the US of a product containing the patented technology? Now, on the second question, the court had addressed that issue in the context of copyright law back in 2013 in this Kirstang versus Wiley case. So the second question is whether the copyright ruling, which basically says that a sale anywhere in the world would exhaust the distribution right in the US, whether that ruling in Kirstang under copyright law would also apply to patents. The first question, however, was kind of unique. It's one that people had been wondering about as far as contractual restrictions. What if the patent owner says, do not resell, or single use only, or put some other contractual restrictions as Lexmark did? How far can they go and then raise a patent infringement claim if those contractual restrictions are violated? So as far as the contractual limitations, the court ruled against the patent owner. They basically found exhaustion once the patent owner sells it, even if it sells it subject to restrictions. The purchaser of the patented item still has the right to redistribute it. So once the patent owner sells a product containing the patented technology, the purchaser can resell and to a certain extent reuse the product without giving rise to a claim for patent infringement. And very broadly, Justice Roberts wrote the opinion, for the most part a unanimous opinion except on the international exhaustion issue, basically looked at policies that disfavored restraints on alienation. Generally, the common law, if you put some sort of restriction on reselling real property or even reselling personal property, those are disfavored. Often they might even be found to be illegal. That same rationale, Roberts is saying, would apply to intellectual property. However, the court emphasizes that all this means is that you lose your patent infringement claim. You can still get a claim for contract breach. And so the contract remedies are still available, but needless to say, the contract remedies are not as large necessarily as patent damages that, for example, allow treble damages and profits and so forth. So consider prior cases. The right to make patented technology is not exhausted by the sale. So that's important to keep in mind. It's still the law. Nothing has changed in terms of making another copy. So in the Bowman versus Monsanto case from 2013, the court ruled that exhaustion does not give a subsequent purchaser the right to make another copy. That issue in that case had to do with genetically modified seeds. All you do is basically have the right to resell and then do some sort of reuses, such as a repair to the underlying product. As far as international exhaustion, the Supreme Court does adopt international exhaustion for patent law. Rights to sell and to use are exhausted even if the product is sold outside the U.S. and re-imported back into the country. The court basically follows its reasoning from Kirstang versus Wiley, involving the reselling of copyrighted books brought overseas. So that's been a really interesting holding. The issue here, one of the big debates here is, how does this affect pharmaceuticals? As many of the audience might know, many people do go overseas to buy expensive in the U.S. pharmaceuticals that are a lot cheaper overseas and bring them back. Generally, if you do that for personal use, there hasn't been much litigation. Can companies do this now? And we'll see. I'm sure there will be much litigation on this, and that might go up to the Supreme Court as well. But if you read the case fairly broadly, it seems like the reimportation of drugs, patented drugs, it would now be possible. Limitations might be things like food and drug regulations, as well as product liability. But as far as patent law is concerned, that may no longer be a bar to reimportation. Now, the lone dissenter on that issue is Justice Ginsburg. She's long held that international exhaustion doesn't make any sense. She was also the dissenter in Kirstang, so her position here is not that surprising. Okay, Sandoz versus Amgen was a very technical case. I'll go through it fairly quickly. Sandoz filed an application with the FDA seeking approval to market a biosimilar of Amgen's biologic filgrastim. So a biologic is a type of drug, but it's one that's based upon genetically modified organisms. It's genetic based rather than pure chemical based, like a pill or a medical device. And so Amgen sought injunction forcing Sandoz to turn over the application. Amgen claimed Sandoz did not give proper notice of its application. And so an issuer writes under the Biologic Price Competition Act of 2009, which was passed as part of the Affordable Care Act, and was a way to try to create generic competition for biologics, and in fact make it easier to have generic competition than they currently existed for pharmaceuticals. So the Supreme Court held, again, this is a statutory construction case, that the act does not authorize an injunction to obtain copy of the application. However, the patent owner can possibly seek an injunction under applicable state law, and so that's the issue on which the case was remanded. Sandoz did provide proper notification before filing the application. Notice need not be given only before first commercial transaction, which is Amgen's argument. The notice can be given much earlier on in the process, and that would affect even when there is some sort of commercialization. And so this is an important, but albeit a very technical ruling for allowing biosimilars to come to the market sooner. So let me talk about the trademark case, Mittal versus Tam. Here the USPTO denied trademark registration for the mark Slants as applied for by a musical group consisting of Asian American performers. The USPTO denied the trademark registration on the grounds that slants is a disparaging term, and Tam appealed, raising a First Amendment argument. The Federal Circuit en banc, in a divided opinion, but there was a pretty strong majority opinion that was authored by Judge Kimberly Moore, who's pictured here, basically found in favor of Tam, saying that the exclusion based upon disparagement was unconstitutional. It violated the First Amendment. And so anti-disparagement provision violates the First Amendment because it's content and viewpoint based. That basically what the USPTO was doing is saying that there's certain viewpoints we don't like and we're not going to grant trademark registration to them. There are other viewpoints we might like and we'll grant trademark registration to that. And therefore, that's an unconstitutional act. It violates the First Amendment principle that government regulation of speech has to be both content and viewpoint neutral. And so the majority opinion basically was focusing a lot on this, on the denial of trademark registration for the phrase "Stop Islamization of America." The USPTO, it reasoned, was more protective of pro-Islam than Islamophobic or Islamic hatred trademarks. And so Moore's opinion expresses the need to protect Islamophobic marks as well. And so hateful of Islam as well as hateful more broadly gets protected under Judge Moore's rationale. The Supreme Court held, in a slightly more narrow opinion, didn't really get into the content-based aspect of this. It didn't really get into this kind of hate speech aspect of it. It basically said that the provision of Lanham Act allowing a USPTO to deny registration based on disparagement violates the First Amendment. The provision discriminates based upon the viewpoint of the speaker. And this is quoting language from Justice Alito's opinion. The government cannot prescribe, quote unquote, happy talk. So if the trademark is happy, it says good things, it gets trademark registration. However, if it says negative things, it can be ruled out on this disparagement prong. The government cannot favor happy talk over mean talk, if you want to put it that way. And so there was an 8-0 on that issue. And so there's clear agreement that this is viewpoint based and therefore should be found unconstitutional. There was a split, however, on this issue about whether trademark speech is government speech. Four of the justices, Justice Breyer, Justice Alito, Justice Thomas, and Justice Roberts, addressed this question. And the USPTO basically arguing that, if you're dealing with government speech, the First Amendment rules are different. The court, those four justices basically said trademark speech is not government speech; it's private speech. The remaining four justices, Justice Kennedy, Justice Kagan, Justice Sotomayor, and Justice Ginsburg said, you don't need to get to that question. They just said, we're not going to deal with that question because once you found this to be viewpoint discriminatory, that's all we needed to say that this is unconstitutional. So what are the implications of TAM? One of them is that it definitely has implications for the Washington Redskins case. That was based upon the same provision that was found unconstitutional in TAM. So most likely those types of cases that are still in the pipeline would get dismissed. Now there is this issue about moral and scandalous marks that's pending in the USPTO, and that's separate from disparagement. And so the case that's percolating up is In re Brunetti, and that has to do with trademark registration for fucked. And before I get into trouble, I should point out that that's spelled F-U-C-T. And you can see why the Trademark Office denied registration on the grounds that this was scandalous and immoral. Basically curse words like that, the USPTO doesn't want to grant. And so the interesting question is whether this viewpoint neutrality rationale that you saw in TAM would carry over to moral and scandalous marks. So the government has taken the position that TAM, the Supreme Court decision in TAM, does not affect Brunetti. In fact, moral and scandalous marks, it says, are not viewpoint-based. These are just words or phrases we don't like, but they don't express any particular viewpoint. They're just sort of utterances that that are somehow offensive. So we'll see how that moves up. I mean, the court does take a very broad notion of what a viewpoint is, and so clearly moral and scandalous does involve value judgments, that certain words are good and certain words are not good. Viewpoint does suggest more of an ideological or political position. And so, we'll see how broadly the notion of viewpoint gets stretched. Maybe the court, if this does go up to the U.S. Supreme Court, maybe the U.S. Supreme Court will talk about content-based more likely, that, if here the government has to look at the content of speech to deny certain benefits. Content-based issues have been very controversial in the U.S. Supreme Court. There was a case a couple of years ago involving restrictions on signs. That's Marsh versus Gilbert. And the court basically struck down a local ordinance that prevented certain signs from being posted that were based upon the content. But the court really was kind of split as to what does it mean for things to based on content. If you think about lots of types of speech regulations, such as regulations on fraud or even regulations or restrictions on trademark infringement, the government has to look at the content of speech to see whether there has been some sort of fraud. And so does that mean securities laws or anti-fraud statutes are somehow suspect under the First Amendment because the government has to look at content? It's a fairly controversial area, and the court has taken different positions on that and are kind of split on that issue. So we'll see how that happens. If I were to predict, I would imagine what would happen in this case is the Federal Circuit will hear it and say, well, this is just like TAM. The viewpoint rationale that the court articulated applies just as strongly as moral and scandalous marks. And very likely the Supreme Court probably doesn't want to revisit this issue again, in part because the court is split in some ways on this content-based. And so the Federal Circuit may have the last word on this at the end. Okay, cases that are in front of the court next term very quickly. SAS versus Mittal. Must the PTAB issue opinion on patentability of all claims or just the ones challenged under 35 U.S.C. 318A. So these have to do with post-grant review and IPR proceedings where a party can challenge the validity of a patent. And the issue here is if an inter partes review is instituted and not dismissed under this chapter, the Patent Trial and Appeal Board shall issue a final written decision with respect to the patentability of any patent claim challenged by the petitioner and any new claim added under Section 316D. The real question is, can the Patent Office, the PTAB, the Patent Trial and Appellate Board, basically just simply look at the claims that were challenged, or do they have to look at the patentability of all claims, dependent and independent and so forth? So this is going to be another statutory interpretation case. The really big case next term is Oil State Energy Services versus Greens Energy Group. This is an interesting case on many levels. One of the interesting cases, the reasons why this case is interesting, why this case has been kind of controversial, is that the Federal Circuit did not issue an opinion in this case. It basically made its ruling under something called Rule 36, where it just basically issued a judgment, a conclusion on invalidity without issuing an opinion. And so that's been a controversial practice. I don't think the court will investigate or review that particular practice, but certainly it's implicated in this case. The big question is having to do with these post-grant review proceedings, specifically the inter partes review, though this logic would also apply to the PGRs. Are inter partes reviews unconstitutional because they permit the extinguishing of property rights by a non-Article III court without a jury trial? So that's the wording of the cert, the question that the court, so this is exactly that wording. It's very kind of interesting stylized language. The language is basically talking about extinguishing of property rights by a non-Article III court. The non-Article III court at issue here is the PTAB. That's just an administrative court. And the administrative court, by invalidating the patent, is taking away some sort of a property right, and it's doing it without a jury trial. So there's lots of if you take apart this question, there are all sorts of sub-questions here. The first is the authority of a non-Article III court. How far does it go? And then this issue about whether there's a jury trial that's necessary to take away a property right. On that latter question, I think if you look at the history of property decisions, there are lots of ways in which property rights get taken away without a jury trial, even in the Article III context. So that may weigh in favor of upholding this particular proceeding. Whether a non-Article III court can do it depends upon the review. It is appealable. The thing that's interesting about the statute is that the appeal has to go directly to the Federal Circuit. It doesn't go through a district court. Now, that's not that uncommon, but that might be a way in which this statute is vulnerable. Now, this particular question I really don't like. It's so broad that at some level, it really does depend upon ideology more than legal analysis. But I think there are some interesting legal questions that the court can hang its hat on without getting into a kerfluffle or a tiff or whatever your favorite word would be, over the underlying ideology of property rights. So as I mentioned, the Act allows only appeals of IPRs to the Federal Circuit. So there is a ready fix if the court finds a problem. The court might say that, in order to protect the due process rights of the property owner, the patent owner, you have to give them the opportunity to appeal to a district court. And then, of course, they can go on to the Federal Circuit and beyond. But that might be a way on due process grounds to say that the IPR is, might have a problem, but it's one that's readily fixable. So those are the two cases. I'll definitely have we may have some webinars later on in the year, maybe in April or May, when those two cases are argued and certainly decided. Very quickly, I'm going over time. As you can see, there's a lot to talk about, and then there were questions. Summary, take-home messages for litigators, what to look out for: latches, patent venue, First Amendment as a defense, 271F1 claims and substantial, design protection and copyright, injunctions and biosimilars, damages in design patent cases, and then exhaustion as a defense. Some or all of these, or at least some subset of these, probably are going to affect a large set of practitioners. So these are fairly interesting, technical, important cases in that respect. Take-home messages for transactional lawyers. How do you structure transactions after Lexmark? I'm hearing that a lot of folks in the pharmaceutical industry are thinking about how to structure their distribution deals for pharmaceuticals so they are, to quote the language, Lexmark bulletproof, right? So that Lexmark won't strike down those contractual arrangements. I think it's going to be very difficult because the opinion was very broad, but we might see some creative lawyering on this front, and I'll be glad to take questions, and maybe it'll be worth another webinar to talk about that. Manufacturing, patented inventions, and the value chain. As you see in the Promega case, there's lots of discussion about the value chain. Actually, I didn't mention that in my discussion, especially in the oral argument. So the court is aware of how manufacturing occurs globally, and that might have had something to do with why they were kind of nervous about coming out against the manufacturer in that case. Trademark prosecution. If you engage in prosecution as a transactional lawyer, the TAM case certainly has some implications for what you do. Seeking a FDA approval for biosimilars and the notice issue. And then both the Apple case and the Star Athletica case have implications for how you want to register your design copyright, as well as in terms of how you want to prosecute or specify your design patents in order to deal with this component issue. So there is an end. There is light at the end of the tunnel. I appreciate your time in listening to this. I think most people made it to the bitter end. Quick conclusions, mix of cases during the last term. Most of them were straightforward technical issues. There were some long-standing issues, as in the Star Athletica case. Some are very hyper-technical, as in the Sandoz case. Open questions have to do with protection of design, state injunctions and biosimilars. We know about First Amendment and trademark. We don't know how broad that protection is. We also don't know whether TAM has opened the door for further First Amendment defenses in copyright and maybe even in patent law. And so next term, we'll see if there's more of the same technical issues with great practical importance that do touch upon some interesting policy concerns as well. So thank you for your time and your patience. I hope you found this informative. Feel free to email me at the Technology Commercialization Law Program or email the Technology Law Center with your questions. My work email is sghosh01@syr.edu, and you can also Google me and find me on the Syracuse Faculty Law webpage. So have a good afternoon, and look out for our next webinar, the next one being planned for September 14th on the battle over CRISPR. So thank you again.